Hi guys. Sorry. Hi guys. What's up? Welcome back to this another new video of Crazy Self Talk, where I used to discuss about myself and try to extend some information on some agenda that I find important and useful in our lives, especially in the life of a lawyer. So yes, I am again back with another new video. So how is my haircut? First of all, my beard and all. Actually, I've got a new haircut and beard, so yes, I hope it is looking cool. Actually, I'm suffering from some ill health, and I've got sour throat and runny nose. So my voice has quite changed. It has become quite heavy. So please bear with me for few minutes. I will talk just about some important thing and then I will wrap up this video. So you do not have to worry about it. So yes, let's begin with the video. So today I went to court and yes, I learned many things. So yesterday, I'm just giving a recap. Yesterday we talked about like how to address your argument in a appellate court, because appellate court mostly the appeals are filed. Appeals along with writ petitions and other petitions which are of public importance or which are of grave importance that they are to be addressed in the court. So while addressing your arguments, like while going to the appellate court, you should address argument both on law and fact. This is the highlight from the last video, because if you play only on law, then it will look like boring, and and it is not at all connected with the facts of the case. So, and if you play on only on the facts, then it will look like you are just playing practically, and you are trying to extend the evidences, tender evidences before your lordship. So yes, this is the thing you should keep in mind. This is very sacrosanct thing, and it is a mantra of to being to get order in your favor in the appellate courts. So yes, today I will also talk about some similar thing. Yes, so sorry. So yes, so today what I was thinking to discuss with you is that when you are filing a petition, particular type of petition, then curate or articulate your arguments surrounding on that petition only. Like they should be dedicated to the title. For example, if you are filing petition and putting your arguments on requesting of FIR, for example, under 528 of BNSS, which is the inherent power of High Court. So you should draft your argument like in a way to address only the quashing part. Like you should first understand what are the grounds of quashing which High Court entertain. So some of which are like if there are procedural discrepancy and not mere technical discrepancy, because mere technical discrepancy is no ground to quash the FIR. If some huge abuse of law has been done in the procedure of the court or in the trial proceedings in the trial, then you can approach to High Court to get your FIR quashed. Otherwise, they will just throw your petition aside. If you just ran to High Court for every small thing, like if in a case charge sheet is not yet filed and you are running to High Court to get quash it for quashing the FIR, then it is next to impossible, because the justice under whom I am interning, her policy is that if FIR is not being prepared, then there is no ground to quash. Like let first the FIR be prepared. Oh, sorry, COVID charge sheet be prepared. Then we will see if there are some offences made out or not. Then you can have a look as stand to approach the High Court. So yes, this is about the quashing, and if you are so at that stage, you should not tender evidences. You just have to play on the evidence. Sorry, procedure. If there are some procedural irregularity and a patent defect in the trial court order, then it is it can be a ground of course. It will ultimately depends on the judge's discretion, but this is the few takeaways that I observed and I would like to share with you. So yes, this is the thing. And now talking about any other type of petition or appeal. Yes, appeal of appeal from the conviction, let's say. If you are convicted on some offense in the lower court, then for making the appeal to high court, it is very like difficult, and you should be very meticulous while drafting the petition for appeal. For example, if a district court or a session judge uh, convicted and accused for 7 years imprisonment, might be a very grave offense, so they have punished it for 7 years. So yes, and if you are appealing to high court, you should uh, challenge the assail the impugned order of the learned session judge or whichever learned court has passed that order. So yes, you should deeply analyze that order, and you should find discrepancy which are grave. Like it is not that some mere technical irregularity you are just taking for the high court. The high court will not entertain it, because district courts are not joke, and you should not take them granted. Like if they pass any kind of order, you can simply run to high court. That should not be the case. You should first fight your case diligently in the lower courts. Then if there are some discrepancy or you are aggrieved by some grave irregularity, then then doors of high court are open. Otherwise, they will thrash you. They will dismiss on the face of it. And one more thing, if you are having the filing the FIR or sorry petition before the High Court, and you are thinking that there is no ground and judge will reprimand me and put some cost, then you should engage some senior, because now things are not in your hand. If there are some good merit on the case that you are fighting before the High Court, then you should appear by yourself. Otherwise, you should hire engage a senior advocate, because what happens is face value matters a lot in the appellate courts. If some senior counsel is standing and arguing something, the judge cannot outrightly deny the arguments or deny the prayer. They take it very seriously and they hear the senior counsel very patiently. Like they just take into account every single argument, every single judgment, and that a senior counsel extend. So yes, if your case is messed up, and you should know how at what stage it is like messed up, and it is not in your hands, so you should engage any good senior counsel, so that at least it will not get dismissed, and rather it will get disposed of. So yes, this is the thing that I would want to share with you. Let's keep it this video here, and I'm trying to make the video precise and concise, and I'm trying to constrain myself up to this length only, so that video will look good. And yes, I think that's it for today. Don't let's meet tomorrow with some new interest, with some new knowledge about law. Thank you so much for watching. Bye bye. Take care. Bye bye.